Buenas tardes para todos. El día de hoy damos inicio a un evento de gran importancia para la Facultad de Derecho y Ciencias Políticas y Sociales, a través de los posgrados, que es Language Across the Curriculum, el cual tendremos la gran participación del doctor Mauricio Uribe, docente de la especialización en Derecho Penal y Criminología. Este evento es de gran importancia para nosotros porque fomentamos el uso de la segunda lengua en los programas académicos. Para ello nos acompaña el día de hoy el doctor Carlos, coordinador del Centro Internacional de Lenguas y Cultura, y el doctor Mauricio Uribe Ruiz, quien nos estará orientando una conferencia de un tema disciplinar de gran importancia. Bienvenidos a este espacio y agradecemos que nos acompañen el día de hoy. Doctor Carlos Fernando, tienes el uso de la palabra.
Thank you very much. Now, Dr. Mauricio Uribe Ruiz is a bilingual lawyer specializing in criminal law and evidentiary matters. He holds a master's degree in law with an emphasis on criminal and criminological science, and he is currently pursuing doctoral studies in law. Dr. Uribe Ruiz has distinguished himself as a member of the observation groups sent to United States and USAID and the U.S. Embassy. He was also finalist in the Techniques of Criminal Oral Advocacy competition organized by the Department of Justice, USA, and the Program for Culture of Oral Advocacy. Dr. Uribe Ruiz is presently a university professor where he shares his extensive knowledge and experience with the students. His conference, titled Evidentiary Assessment, promises to offer valued insights into the critical aspects of evaluating evidence with the legal systems. Welcome, Dr. Mauricio Uribe.
Dear Carlos, you are too kind. Good evening, dear colleagues. I hope I find you well, and I have to start thanking the university for this opportunity, as well as all of you for joining us. And I must say that it's a pleasure for me today to speak with you about a very important topic, that is the assessment of evidence. This thematic is of great relevance when we are in the court system and in the evidentiary system. We constantly interact with other people seeking information. This can be as casual as asking someone for directions, the time, or how the weather has been. But we can also be searching for relevant facts that let us choose a career, make life decisions with a partner, or even to rule about the well being, rights, freedom, and life of a person. Daily, we constantly debate whether or not we should believe what other person tell us, which we consider very carefully. Taking more precautions, the more relevant the decision we are going to make is. The criteria we use to decide if we believe or not in somebody may be different from the type of information that we are looking for. For example, sometimes when we ask somebody about something, we ask ourselves if the person that is giving us the information wants something in exchange of have a interest in the outcoming of the negotiation. We also sometimes ask ourselves, is the person that is giving us the information is trustworthy, and if we can believe in the things that he is saying. These two factors, among another ones, is what we use every day in our real life to make decisions. Every time we speak with somebody, we want to know if we can trust them, if we can believe what they are saying. However, in the judicial system, sometimes it seems that the determination if someone believes or not in a person is capricious or arbitrary. And sometimes it looks like it's based on prejudice and assumptions, such as all people tell the truth if they swear, or the accused always lie. The money make people more honest. Women always tell the truth, among other unsubstantiable and clearly contradictory justifications. This is a real problem because if we don't have a criteria established to know when we can believe or not believe the declaration, the testimony of a person, the decisions that we make are going to be hazardous and they are not going to respect the law and they will never amount for justice. Is for that reason, or is precisely this reason, why we have to analyze and study if the norms, if the law establish criteria for evaluating evidence. Since it is this and not the whims and assumptions of the decision makers that should indicate when we believe or not an statement. In the civil system, the Article 167 indicate, in reference to the burden of proof, that it is the responsibility of the parties to prove the factual assumptions of the rules that ensure the legal effect that they seek. In criminal matters, Article 7 of the Law 906 of 2004, it is said that the persecution is the one that must demonstrate the guilt of the accused. This is based on the principle of presumption of innocence. This means that in our legal system, the parties involved through evidence must prove that an event occurred in the phenomenological world and have to explain why that fact is described in the law. So the judge can impose the legal consequence that the rule indicates. If the prosecution proves that the person commit acts that are described in the law as a crime, the consequence is a sanction. While if these acts are not proven, the defendant must be acquitted. Consequently, the relevance of this topic consists in indicating which are the criteria that the judge must take into account in order to give credibility to the evidence and thus be able to conclude whether the facts are proven or not. In Colombia, this criteria we have to apply it to the different kind of evidence that we can use. In the criminal law, the most common evidence are the testimonies, the expert testimonies, the material evidence, the documents, and the judicial inspections. The testimonies consist of a person recounting the events that he witnessed directly through his senses. This is the reason why they are called witness. The witness is the person who sees something, hears something, and then is going to tell us what he saw or what he heard so we can know the information that he has. Because he witnessed the event, we call them in that way. The forensic evidence, that is also the expert witness or the expert, refer to a person who have knowledge in a science, in an art, or in a trade, and he apply this special knowledge that he or she possess and report what he or she finds or conclude. Example of an expert witness or a forensic evidence will be the DNA test, a chemical that tells us what substance we find, a doctor that can tell us the cause of death, among others experts that can give us information that the common person don't know. Material evidence is any type of object, things, fingerprints, or traces that can be related to the case. And their main task is to demonstrate his own existence. Generally, the work of experts involve the development of these elements that we mentioned. And the documents, on the other hand, are material evidence that tell us something other than their own existence. There are many kinds of documents, and the information that they give us depends of the type of document that we are talking about. For example, it's not the same speak about a video or a photograph or a recording or a piece of paper, because each one of these have the purpose to prove different subjects. For example, if we have a contract, what we want to prove is that there is a accord or a business doing between two people. But if we have a video, what we want to show is what happened in that video. Finally, the judicial inspections consist of the, or is more like an official have to travel to a place and see the place, know how it is and know his characteristics. So in that way, he can have the knowledge or the place where things happens. These are the mm, most common proof that we use in our judicial system. In general terms, the evidentiary assessments that we apply in Colombia is called rational persuasion. We have to know that we apply this system of evidence because the constitution of our country imposed it. In the civil code express the rational persuasion is how the judges will analyze the proofs, but they never say how this apply or where this apply. The reason why the code have this information is because the constitution imposed that this is how the judges must value the proof that they know. This system of evidence consists that the judge established for himself the value of the evidence based on the rules of logic, science, and experience. In this system, the one that make the decision, the judge, have to evaluate the evidence and with sound knowledge conclude if he believe the evidence or not, determine explaining what the evidence says and if the facts in the case are proven by the evidence or not. The rules of science are the principles that govern the world. That is the law of gravity, the rules of physics, chemistry, biology, geology, math, and so on and so forth. These, in theory, are immutable and allow us to make predictions and assessment. The fact that two things cannot occupy the same place, the speed, distance, that no one can be in two places at once, these criteria are what have allowed the advance of humanity and are present in all our actions. The law of transfers, the law of matter, and causes and effects are common in the criminal trials. These rules imply the application of technical and specialized knowledge relevant to the cases. For instance, in a domestic violence case, scientific studies about the behavioral patterns or psychological impact on victims might be presented, helping to understand the situations more deeply. The rules of experience, on the other hand, can have scientific or social basis. These are characterized by what normally happen and is what generally tend to happen in some events and are known from day to day. Those that have scientific basis, even if we don't know what these bases are, tend to be generalized in the world. Black clouds, for example, indicate that it will rain. Ice or water on the floor make it slippery. If I stop holding an object, it will fall to the floor. What the rule of experiments have and social sources. Okay. In the other hand, when the rule of experiment have a social sources, the conclusions can change from one place to another. They use given to certain establishments, for example, the interaction expected with strangers is not the same in every town. The time that you can take to go to one place to another in a city, these are things that we know because we live it day by day basis, but they are not the science or the rule of the world that impose them. It's just what is common in a place and in a time. These rules apply the general knowledge acquired by people in his lifetimes. The judges must consider accept social experiment and practice when evaluating evidence. For example, when we are in a place like Bucaramanga, is different than the treatment or how we uh, interact with other people in Armenia, in Bogota, or in Cartagena. So in these cases, we don't have to use the same rituals or the same knowledge. In small towns, it's common that people go to parks in the middle of the square place and drink and have company. In big cities, this is not a practical notion or this is not do every day. So this is what we call the rules of experience that can change from one place to another. Finally, the rule of logic, although they are various kinds, the most common from ancient Greece and are coined by Aristotle, such as the principle of identity, non-contradiction, and excluded middle. There are other rules such as the one of the sufficient reason, which was developed many years later. This rule is used to assess the information available, and they help us to interpret the facts we know. These rules are based on formal reasoning principles where analyze is aimed at establish valid inference. For example, if a circumstantial evidence indicate the presence of the accused at the crime scene, its interpretation must be consistent with other available evidence to avoid erroneous conclusions. The rule of rational persuasion must be applied to the evidence that is debated in court, and it is with them that we can determine whether the information we obtain is credible or not. The information that a declarant offers may be contrary to reality in two main situations: that he or she is lying or that he or she is confused. Lying implies that the person knows what really happened, but in court decide to give information that is different from the real one. This may be due to a personal interest of the person offering his or her version has in the process, due to a relationship with one of the parties, or due to interference of a third party. Confusion, which is more common, may arise to the problems or situations that occur at the time of obtaining the information. The ways of the person seeking to obtain the information, ask the question, memory problems, the contamination that the information may suffer, or the time that has passed. For this reason, when analyzing evidence, the same regulation indicate the criteria that must be considered when evaluating it, which applies to each demonstrative element and are derived from the rules of sound criticisms already developed. Regarding testimonial evidence, the article that refers to its evaluation criteria is the 404 of the law 906 of 2004, which says the following: to evaluate the testimony, the judge will take into account the technical scientific principles of perceptions and memory, and especially what is related to the nature of the perceived object, the state of sanity of the sense or senses by which the perception was had, the circumstance of place, time, and manner in which it was perceived, the process of recollection, the behavior of the witness during the interrogation and cross examination, the form of his answers, and his personality. From this, we can extract 7 different criteria to consider when we can say a witness is telling the truth or is lying. First one, the characteristic and particularities of the element that he was perceiving, his shapes, his size, if when he perceived the event or the object, it was violent in nature, if he was in danger. These are things that we have to consider because can make the person confused. The second criteria is the state of health of the senses of the person who perceives the information. It's not the same if you have problems with your eyesight, or if you have problems hearing, or if you were drunk, intoxicated, or in an emotional state that prevent you from understanding or knowing what was happening. In these cases, this information is relevant to determine to know if the person is telling the truth or is lying. Third, the circumstance of the place, time, and manner in which was perceived, if there was light, the distance of the object, how long he could see it. All these criteria you have to take in account, because if you are in a dark place, it's really difficult or impossible to see what is going on. The same thing happen when you are in a bar, you are dancing with somebody, the music is really loud and you can't hear what the person is saying because the music prevent you from doing that. These are the things that the judge have to take into account when someone say, I hear this or I see this. The judge have to analyze if the person really could get this information or perceive these elements. We also have to be accounted or have to take in account the memory of the witness, his behavior, how he responds to the question he is asked, and his personality. Because all these elements are needed to know if the person is telling the truth or is lying. We have to include this aspect when we are doing a direct examination and in the cross examination, as well as indicated in the closing arguments of the party and in the decisions. The judge have to indicate why he give credibility to one witness and not the other. For these purposes, we advise the lawyers when they are doing the direct examination, always start asking the person not also his identification, but also questions about his personality, what he like, what he dislike, if he have any relation with the person that is being processed or with someone in the audience or in the place, what his work, what he study. We also need to know how are his senses, if he knows about the information he is given or not. This is really important because this is the only opportunity we have to the judge know these things. If you can see the presentation in the screen, you will see a picture in the left side of the screen. When you see this picture, normally, if you are over 5 years old, you are going to see a couple, a woman and a male giving a hug in a sexual or in a erotic way. But if you are under 5 year old, normally you are going to see dolphins and you are not going to see the couple. That's because our maturity or our knowledge allow us to see some things that other persons can see. In real life, this happen all the time. A lot of times you see something and even another person is looking the same exact thing, he have a different information. So only these kind of questions can allow us to know these facts and to allow the judge to have adequate assessment of the information that is given. After this, it's important that we ask the witness how was the place where he have the encounter or where he perceived the object. If he was drunk, if he was angry, if he have a good problem, how was the light, how was the sounds of the environment. All these criteria is what will give the judge the security that this person can be sure of what he is saying. If we don't do this, the judge is not going to know how to assessment the declaration that we are giving to him, and he will cannot put it in the sentence. Others evidence have their own criteria to be analyzed. For example, when we are talking about the expert witness, this is in the article 420. And the criteria that we have for assess his information are about his experience, his knowledge, his moral uh, suitability, how clearly and accuracy he answered, how he behaved, and if his science is able to give this information. A common error that you see every day in the justice system is that when we get an expert witness, we just ask him, okay, tell us what is your expertise and what are your conclusions. But in this way, the judge can know why he gives this information. The judge will not know why he can, with his science, know that for sure. So, taking in account the criteria in the 420, we have some tips that we have to use when we are asking questions to our expert witness. For example, we start always asking about his knowledge, his theoretical knowledge about his science, trend, or art. It's not a quiz. It's not asking questions to know if he knows the answers. It's asking him how he knows that information, how he acquired the knowledge he have. He went to the university, he is empiric, how he know about all the things that he's going to declare. We also want to ask him about his experience. Is this means if he have work in this area, if he have knowledge in the ground of these topics that he is going to declare. When we ask about all this, then we have to ask him about his science in general, why his science can explain us what we want to know, why his science can do this and how they do it. Only when we do this, we can go forward and ask him in the case in relevance what he did, why he did it, and how he did it. And then he can give us his findings because we can trust blindly in someone. We can't just because he's an expert understand that everything that he says is true because he can make a mistake or he can have an interest to lie in the court. The other evidence that we mentioned, the documents and the evidence, material evidence, normally they seek two criteria to be assessment. In the material evidence, what we want to know is that the elements, the things haven't changed. They are in the same way that they were fine, and the judge can see us how they were fine. When we're talking about documents, we want the same thing, but also we want the information that the document give be precise and clear. If the document can give us the information in this way, we can know what they are going to tell us. We also want that the content of the document is in accordance with what ordinary occurs in the word. The evidence must always be analyzed individually to determine if we give them credit or not, and then to a cross analysis with the other element presented. This will allow to identify the coherence of the stories and the power of convictions. But the criteria to be taken into account are those set out in the legislation and not personal or discriminatory ones. Only in this way can it be guaranteed that the truth is reached, the principles of law are respected, and the legal certainty is achieved, being the job of the lawyers to bring this knowledge to the decision maker, and that the person who make the decision to expose them in their sentence. To conclude, my dear friends, we have only to add that every day when you go out to the street, when you talk to people, when you are in your job, you are doing elementary assessment. When you decide to to believe in someone, you are precisely doing this. And to do it better, we always have to make an integral approach is analyze all the evidence, stop the biases, don't go to prejudice to take decisions, and always try to take your decisions in justice and equity. Thank you very much. Ana Lucia, you are just too kind, and thanks to the auditory.
Doctor Mauricio, muchas gracias a ti por este escenario tan valioso que el día de hoy nos brindas, por esa información, por el discurso. Te agradecemos mucho por este escenario y darle los agradecimientos a todas las personas que se conectaron y nos acompañaron hoy en esta conferencia en el marco del programa de Language Across the Curriculum que se desarrolla la Facultad de Derecho y Ciencias Políticas y Sociales en acompañamiento y articulación con el Centro Internacional de Idiomas y Cultura de la Universidad La Gran Colombia. Agradeciendo a todos, un abrazo muy fuerte y recordarles que la Universidad La Gran Colombia es una experiencia de vida. Bendiciones, saludos.